This court's order as far as releasing the tape or any transcript from the tape to the public, not to the parties, but to the public, would still stand until we have an opportunity for the parties to review the report and file any motions they feel are appropriate. As far as the arraignment, let's take care of that for the clerk's benefit. And what I would indicate, I know that there are jurisdictional issues that have been raised by both parents, and what I would indicate that I would allow them to reserve any jurisdictional arguments no matter what plea they enter. And would I be safe in assuming that both parents would be entering denials to the petition and requesting a trial if jurisdiction does in fact exist?
Yes, Your Honor. Yes, Your Honor.
Okay. So we'll enter denial on behalf of the parents. What we'll probably do is set a pretrial out beyond when I think we can get a mediation. I know that the parties may, if jurisdiction continues, wish to do depositions, and some of those may end up being in Ohio, so we'll address that as we move along.
Judge, I don't know if Mom and Dad are going to be at the mediation, but we would certainly think that it would be very productive to have them present in person, and if not in person, at a very minimum, appear by phone as parties to the matter.
Well, I would agree that we probably have the most success if they were present in person, but because they live in Ohio, I certainly would not require them if they need to appear by phone, but I would require them to appear by phone because I agree that mediation wouldn't mean much if we did not have them.
Thank you.
It's important that we get somebody involved. The judge has the discretion to get somebody involved who knows dependency, who has understanding of family and child psychology, who can basically bring these parties together on both sides. We need somebody in the middle, Judge. That's why I've moved for an attorney ad litem.
The court does agree that it has the authority under Chapter 39 to appoint an attorney ad litem on behalf of the child. So now let's get to the gag order that was requested by the guardian ad litem.
As you know, it is a limited gag order. I'm not seeking to restrict the media's access to the courtrooms, to the proceedings that are occurring. What I am asking is to restrict the parties, their attorneys, and any participants and their attorneys. I did not include witnesses in here.
This case is about her and about her safety primarily. And what is interesting is she says, no, Mr. Stenberger, this case is not about me. This is about thousands of people like me all over this world. And she says, I want my story to be told. Having said that, Your Honor, we have talked for a great period of time. We have sought counsel from a number of sources. And we, on behalf of the child, are prepared to join the GL's motion to gag this process in terms of the meeting.
Judge, what they have done, Mr. Stenberger, and I believe at this point, because of the motion, the GAL included, have completely made a case about Muslims in Columbus, Ohio. You just have to look at the ridiculous document Mr. Stenberger filed, which has no evidentiary value. And now they say it's okay, because they've done their job, sir. And Your Honor, I ask on behalf of my client, where is his right to stand up and say, look at my situation, look at who I am. Don't look at my religion, look at how I raised my family. Judge, this is what he's doing, and it's troubling them. That's why they came and blocked the FDLE report. And Judge, that's why they're moving for the gag order. If, Judge, you allow this gag order today, what you would do essentially is stifle my client's First Amendment speech,